bienvenido a mi canal. Yo me llamo Desiree. Soy una abogada afrolatina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Charlie Adelson. Si quieren más video en español, nomás dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, as I make this video, I literally cannot contain my excitement. I literally cannot contain it. I want to shout it to the mountaintops. I want to shout it to the rooftops. I'm just so excited to give you guys this Charlie Adelson update. But without any further ado, let's go ahead and get into it. Today is July 4th, so this is the 4th of July, and I'm working for you guys. You're welcome, because I love you so much. You're welcome. I don't know when this video is going to go up, but you're welcome. And I'm just sitting here working for you guys. Anyways, all that to say, I found out that probably like 2 days ago, Charlie Adelson's appeal was denied, and his convictions were affirmed. And without any further ado, it's going to go... Sorry, I'm jumbled. And without any further ado, we're going to go ahead and get into talking specifically about the opinion that was issued here. Oh my gosh, I'm so excited. Let's go. Okay, so as you guys can see here, it says First District Court of Appeal, State of Florida. Charlie Adelson, or Charles Adelson, is the appellant, and State of Florida is the appellee. It further says, on appeal from the Circuit Court for Leon County, Stephen S. Everett, Judge, July 1st of 2026. Dan Markell, or Markell, was murdered at his home in 2014. In the 12 years since the murder, 5 defendants were charged, convicted, and sentenced for their roles in the plot to murder Markell. Charles Adelson, Markell's brother-in-law, was the 4th defendant to be convicted. After a jury trial, Adelson was found guilty of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. This is his direct appeal. Adelson argues that the trial court erred when it denied his motion for change of venue, denied his motion to strike the veneer panel, refused to enter into evidence certain text messages, and excluded hearsay evidence from a recorded phone call. Adelson also argues that the cumulative effect of the alleged errors deprived him of a fair trial. We affirm without further comment Adelson's 3rd and 4th claims of trial error and his claim of cumulative error. As we explain below, we also affirm his first 2 claims of error. You guys, this is so monumentally laughable. I don't think you guys even understand. In my last Adelson video, specifically about Charlie, I'm pretty sure we went through the oral arguments that were had on his behalf and on behalf of the state of Florida, right? I went through each of the arguments that his attorney was making on his behalf, and I told you guys my opinions about them. The court here is saying, listen, we affirm, but we're not going to get into all the ridiculous arguments that we're making. We'll explain 2 of the arguments down below, but everything else affirmed. Affirmed. It is so riveting. Let's carry on. Adelson argues the trial court erred when it denied his motion for change of venue. About a month before jury selection began, defense counsel moved to use an 11-page juror questionnaire to aid in the selection of a fair and impartial jury. Defense counsel asserted that there was a legitimate concern that the publicity surrounding Markell's murder had so infected the community that a change of venue may ultimately be required. The court denied the motion, finding that individual voir dire would satisfy defense counsel's concerns about pretrial publicity. Jury selection was conducted over 3 days. The court called in a panel of 50 prospective jurors at a time, read a brief description of the case, and determined whether the prospective jurors were qualified to serve. Due to the publicity surrounding the murder, the court individually asked 130 prospective jurors some form of these questions. 1. What do you know about this case? 2. What are the sources that you've obtained this knowledge from? 3. Based on what you know, do you have an opinion about Adelson's guilt or innocence? 4. Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence that is presented in the courtroom? 5. Can you be fair and impartial? After hearing the responses to the court's questions, the prosecutor and defense counsel were permitted to ask follow-up questions. Out of the 130 prospective jurors interviewed, 96 had heard about the case. 54 of those 96 prospective jurors admitted that they had formed an opinion about the case, and 53 of them believed that Adelson was guilty. The trial court excused all 54 prospective jurors who had formed an opinion about the case. The remaining panel members returned for groupe voir dire. After the trial court and counsel had individually questioned all 130 prospective jurors, defense counsel orally moved for a change of venue. Counsel argued that the prospective jurors' responses during individual questioning showed that Adelson could not receive a fair trial in Leon County because of the extensive pretrial publicity surrounding Markel's murder. Counsel argued that, as demonstrated by the answers from the mayor of the city right down to the citizens of the county, there is not a single person, except for one man whose opinion I discount, that has said anything other than this man is guilty. As for prospective jurors who admitted that they had been exposed to publicity about the murder but claimed that they had not formed an opinion about Adelson's guilt, defense counsel contended that the court should not find them credible. The prosecutor objected to defense counsel's argument that a fair trial could not be conducted in Leon County. The prosecutor pointed out that in just 2 days of jury selection, roughly 60 of the prospective jurors individually questioned by the court had passed the publicity test. Based on the responses given by the prospective jurors, the court denied the motion. The court noted that several prospective jurors indicated that they had no exposure to this case whatsoever. The court further explained that the other jurors who have had exposure to the local media have indicated that they will follow the law and they will render a verdict that's based solely on the evidence. The case went on to groupe voir dire. When selecting the jury, both sides exhausted their peremptory challenges, 10 for the main jury and 1 for the alternate. At the end of jury selection, the trial court asked Adelson if he accepted the jury. Adelson replied, "Yes, Your Honor." The trial court then swore in the jury. Defense counsel did not renew the motion for change of venue before the jury was sworn. Adelson argues the trial court reversibly erred when it denied his motion for change of venue, depriving him of his constitutional right to trial by an impartial jury. He contends that the community was so pervasively exposed to prejudicial media coverage about Markel's murder that it was impossible for Adelson to seat an impartial jury in Leon County, and he asserts that prospective jurors who claim to have no information about the murder or who claim to not have formed an opinion about Adelson's guilt should not be believed. The United States Constitution and the Florida Constitution guarantee a criminal defendant the right to a public trial by an impartial jury. Jurors are considered impartial when their minds do not contain any element of prejudice for or against either party in a case to be tried before him, and when the jurors can render a verdict solely on the evidence presented and the law given by the court. And the test to determine juror partiality is whether the juror possesses the state of mind necessary to render a verdict in accordance with the evidence and not based upon preconceived opinions. But to be impartial, must the jury and individual jurors be ignorant of the cause to be tried, not at common law? Then it was expected that jurors drawn from the community would be knowledgeable about the case and that they would decide cases based on their personal knowledge. But over time, it was recognized that the convenience gained by an informed jury could be undermined by another very natural and almost unavoidable inconvenience, that jurors coming out of the immediate neighborhood would be apt to intermix their prejudices and partialities in the trial of right. To avoid this problem, the American criminal justice system moved away from one impaneling juries with informed jurors to one seeking to impanel juries with little to no knowledge about the case. But even under the modern trend, jurors need not be ignorant of the cause to be tried before them, nor does knowledge of the cause necessarily render a juror partial. This is true even for juries for trials involving high-profile crimes, when members of the veneer will have been exposed to some information about the crime through pretrial publicity. Pretrial publicity will give rise to a presumption of prejudice among the members of the veneer only in the most extreme circumstances. A change of venue is appropriate only when the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that the jurors could not possibly put these matters out of their minds and try the case solely on the evidence presented in the courtroom. Adelson argues the pretrial publicity surrounding his trial was so pervasive and inflammatory that it was impossible to impanel an impartial jury in Leon County. As we will explain, he failed to preserve his arguments for appeal, and he has not met his burden to show fundamental error. Okay, you guys, before we go any further, let me go ahead and explain that to you. Do you guys remember that during oral argument, Adelson's attorney made this same argument to the court, right? Basically, that the court erred because it was not a fair and impartial jury, because some members of the jury panel had already heard about Adelson's case, right? And then the justices who were opining about the case asked, well, did you not fail to preserve that argument by accepting the panel and not objecting at the time? And then he said, okay, cool. Let's assume that's the case. We still can review this for fundamental error, right? What this court is saying is not only did you fail to preserve the argument by not objecting to the panel before it was seated, you also failed to establish any fundamental error. So on both fronts, you're a failure. And for those reasons, we affirm the convictions. I don't think I've been so excited to share a case update with you guys in so long, but let's go ahead and carry on.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, three actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
No,
was there?
I understand. But again, to that, I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning is no longer good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds it is not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental
my understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with a change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion. And they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved. And they did so under the fundamental error standard. And so, I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure. Well, yes. But so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
If defense counsel had said, if the question rather than to Mr. Adelson, do you accept this jury? And let me point out, you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections? Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record.
Adelson contends that the trial court's denial of his oral motion for change of venue violated his rights to an impartial jury under the federal and state constitutions. But even constitutional rights are subject to preservation requirements. And here, Adelson failed in two ways to preserve his challenge to the trial court's ruling. First, he failed to make his motion in writing. To secure the constitutional right of a criminal defendant to a public trial by an impartial jury, the Florida Supreme Court adopted Florida Rule of Criminal Procedure 3.240. Under that rule, a defendant may move for a change of venue when a fair and impartial trial cannot be had in the county where the case is pending. The rule requires that a motion seeking a change of venue be in writing. The rule also requires that the movant to attach an affidavit setting forth facts on which the motion is based, and a certificate by the movant's counsel that the motion is made in good faith. Adelson did not comply with the rule in several respects. He did not file a written motion. He never submitted supporting affidavits to show the extent of pretrial publicity, nor did he certify that the motion was made in good faith. Due to these failures, Adelson's challenge to the trial court's ruling on his motion to change venue was not preserved for appellate review. Second, notwithstanding his failure to comply with Rule 3.240, Adelson failed to preserve his challenge to the trial court's venue ruling because his counsel failed to renew the venue motion before the jury was sworn. The purpose of the preservation requirement is to place the trial judge on notice that error may have been committed and provide him an opportunity to correct it at an early stage of the proceedings. The preservation requirement prevents a defendant from standing by silently while an objectionable juror is seated and then, if the verdict is adverse, obtain a new trial. Here, it could have been that after voir dire, Adelson and his counsel were satisfied with the jury seated for his trial and made a strategic decision not to renew the motion to change venue. Adelson's counsel did not renew the motion before the jury was sworn. Because he failed to preserve this issue below, we affirm the trial court's ruling on the venue motion, and Adelson cannot show that the trial court fundamentally erred by denying the motion for change of venue.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know. And my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure. But one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that, what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw. And I think that's right. But wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript, there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
Clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just contrary to what happened in 1994, what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, Court TV, shows like
YouTube, Court TV, 2020, Over My Dead Body podcast, Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that, in fact, argued that your client was innocent. So we don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave.
An error is fundamental when it reaches down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. When ruling on a motion for change of venue, a trial court must consider the extent and nature of any pretrial publicity and the difficulty encountered in actually selecting a jury. We begin with the second prong, the difficulty encountered by the trial court in seating a jury. The Florida Supreme Court has instructed trial courts to endeavor to impanel a jury before ruling on a motion for change of venue, explaining that voir dire affords an opportunity to determine whether individuals who have not been seriously infected by the publicity can be found. The trial court followed those instructions in this case. To determine whether impartial jurors could be found, the trial court began by individually interviewing 130 prospective jurors. The court examined the jurors to determine the extent of their knowledge from pretrial publicity and to assess whether they had formed an opinion about the case. Most of them, 96, had formed an opinion about the case. Most of them, 96, had heard about Markel's murder. Of those 96 jurors, 54 had formed an opinion about the case, and all but one of the 54 prospective jurors concluded that Adelson was guilty. Still, none of the jurors who formed an opinion about Adelson's guilt served on the jury. Indeed, the trial court erred on the side of exclusion when the court perceived that any juror had potentially prejudiced the case. The record, as detailed below, also reveals that the jurors actually seated had very limited knowledge about the case. Of the 12 individuals who were selected to serve, 7 reported that they did not regularly watch news. 4 others had heard about the Markel case on the local news or read about it in the local paper, and 1 juror had heard about the case on the radio. What all the seated jurors had in common was that they each communicated to the trial court that they had not formed an opinion about Adelson's guilt and were able to convince the trial court that they could be fair and impartial. Even so, Adelson insists that the jurors were not being truthful when they stated they could be impartial and set aside any knowledge of the murder stemming from partial publicity. He invites this court to look behind the jurors' responses and the trial court's credibility determinations. We must decline the invitation. I'm going to stop right here and just explain to you guys how cold and beautifully put that was. The writing was so stupendous. It was so beautiful. He invites us to look past all of these facts right here. But guess what? We declined that invitation. Oh my gosh. Oh my gosh. You guys, this is beautiful. This is beautiful. But let's go ahead and carry on. This is because we must afford great deference to the trial court's decision on whether a prospective juror is able to lay aside any bias or prejudice and render his verdict solely upon the evidence presented and the instructions on the law given. Great deference is warranted because the trial judge's evaluation of jurors is informed by several factors impossible to capture fully in the record, such as prospective jurors' inflection, sincerity, demeanor, candor, body language, and apprehension of duty. On this record, Adelson has failed to show that the trial court encountered difficulty in seating an impartial jury. After questioning 130 prospective jurors over 3 days, the trial court evaluated their credibility and determined that the jurors seated for Adelson's trial could be impartial. And nothing in the record supports an argument that any of the seated jurors were not impartial. For this reason, Adelson cannot show that it was impossible for the trial court to seat an impartial jury. We now turn back to the first prong of the rolling test and consider whether the duration, intensity, and nature of the pretrial publicity surrounding Markel's murder made it impossible to seat an impartial jury in Leon County. Adelson had the burden to show that the pretrial publicity was prejudicial and inflammatory, and that the prejudicial pretrial publicity saturated the community where the trial was held. When making the discretionary determination of whether pretrial publicity adversely affected the impartiality of the prospective jurors, the trial court must consider 1. The length of time that has passed from the crime to the trial and when within this time the publicity occurred. 2. Whether the publicity consisted of straight, factual news, stories, or inflammatory stories. 3. Whether the news stories consisted of the police or prosecutor's version of the offense to the exclusion of the defendant's version. 4. The size of the community in question. And 5. Whether the defendant exhausted all of his peremptory challenges. Generally, the trial court can make determinations on the publicity factors from the affidavits and other evidence submitted by defense in support of a motion for change of venue. But Adelson presented no evidence below, nor did he make any argument on appeal about these factors. He relies only on the responses of the prospective jurors during individual questioning and voir dire, arguing that their exposure to pretrial publicity created a presumption that an impartial jury could not be seated in Leon County. But he has failed to meet the heavy burden to show that pretrial publicity tainted the veneer in Leon County to the extent that it created a presumption of partiality. Adelson also argues there is reason to doubt that an impartial jury was actually seated in his case. He points out that of the 96 prospective jurors who heard about Markel's murder, 54 had formed an opinion about Adelson's guilt, with all but 1 believing that Adelson was guilty. But Adelson cannot deny that none of those prospective jurors who had an opinion about his guilt sat on his jury. Rather, the trial court was careful to exclude any juror who had potentially prejudged the case, nor can he show that the selected jurors were partial. Okay, let's go back. Do you guys remember how I explained to you guys that I just felt like in oral arguments, his attorney wasn't really making any headway. So basically what he's saying is, yes, the people that sat on the jury said they could be fair and impartial, but we should assume they're all liars. And I'm going to bring up the fact that there were all these people, 50 whatever people, that said that they had already formed an opinion about Adelson's guilt or innocence based on the pretrial publicity that they have received, but they were all excused. But I'm going to use that as part of my argument anyway. Here, the court is calling him on it. And this is just marvelous to watch.
Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They
correct?
were.
On this record, Adelson failed to show that the general state of mind of the inhabitants of Leon County was so infected by the knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that the jurors could not possibly put these matters out of their mind and try the case solely on the evidence presented in the courtroom. And an impartial jury appears to have been seated for Adelson's trial. And so the trial court did not err, much less fundamentally err, when it denied Adelson's motion for change of venue. Adelson next argues that the trial court erred when it denied his oral motion to strike the entire veneer because of the comments made in the jury assembly room by some of the prospective jurors. When jury selection began, the trial court instructed prospective jurors that they should not discuss the case while waiting in the assembly room. Even so, the parties discovered during jury selection that some individuals in the assembly room were ignoring the court's instructions. One prospective juror reported that someone in the assembly room stated that it was a federal case, while another one stated that it must be about the FSU professor. A different person complained that they would be there for a long time. After learning that the veneer was not abiding by his instructions, the trial court returned to the assembly room and again instructed the prospective jurors that there was to be no discussion concerning the subject matter of the case until they were excused from jury selection. Defense counsel then moved to strike the jury panel, arguing that it was impossible to know what else had been said in front of the prospective jurors in the assembly room. The trial court denied the motion, concluding that he did not have a basis to strike this entire panel as a group right now. The trial court then continued with the juror interviews. Two other prospective jurors then reported people talking about the case in the assembly room, with one reporting that someone said that Adelson was guilty. Defense counsel again argued that the pool of prospective jurors had been tainted and renewed his motion to strike the panel. The reports of the prospective jurors discussing the case in the assembly room concerned the court. To alleviate the problem, the court offered to allow the parties to watch the recordings of the assembly room to see what was being said. At that point, defense counsel did not take up the court's offer. The court then denied the motion to strike the panel. The court added that if any independent investigation by the defense yields information that would demonstrate otherwise, I will reconsider the motion. Despite the trial court's open invitation to the defense to further investigate the issue and report back, nothing in the record or in the parties' briefs indicate that defense counsel ever accepted the trial court's offer to view the recordings or to further investigate what may have been discussed in the assembly room.
But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those two, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that, and going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number one, that jurors have not followed the judge's direction. So much so that the judge, when he heard about this after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know—
But the problem is the content of those communications. And they were like this, high-profile case. It's the Charlie Adelson case. It's the Dan Markell case. Which of the— and that he's guilty. But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right?
Right.
So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty
Talking about it, I mean, content. Let's get to the content.
talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the 2 jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing that set of the panel. Let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again. And the judge said, from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have and I can quickly tell you the page numbers regarding those. I have the names. I apologize. I will say them. It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes, multiple times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by that?
Expressing their opinion that the person was guilty. But don't we typically, we're going to strike a panel, or require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors. Just those 50. The clerk actually said.
But the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
Oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the 3rd group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was bad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted.
What's more, Adelson concedes that the trial court removed for cause any prospective jurors who admitted to talking about the case, but he suggests that this remedy was insufficient because it was unknown how many members of the veneer were exposed to conversations in the assembly room about the case. But the trial court afforded defense counsel the opportunity to review the recordings of the jury assembly room for this exact reason, and counsel declined the offer. Based on this record, the defense failed to show that any of the statements made in the jury assembly room tainted the panel, and thus the trial court did not fundamentally err when it denied the motion to strike the panel. Finding no error by the trial court, the judgment and sentence are affirmed. You guys, can I just be honest with you and tell you guys that this is the most glorious thing I have read in forever? I'm just kidding, not forever, but in a long time. I am so glad that the Court of Appeals got this correct, but of course they were going to. It was my opinion even back then that Charlie Adelson and his attorneys were kind of blowing smoke. I don't think that they had a fair shot, and that's because there was no error. Do you guys remember the trial judge in this case? Judge Everett, that man wasn't playing no games with nobody in there. Not a soul. Not you, not me. We weren't there, but like no one in there. Okay. And he got it right. And the Court of Appeals affirmed his decision and affirmed the sentence. I am so excited to share this news with you guys. I'm hoping that somewhere in the near future, we'll see Wendy get charged, you know? I will say that. I think that Wendy was a part of this. I have no information, no inside information, let me say that. So I believe everything is alleged. I believe Wendy was allegedly involved in this, and I believe allegedly that Wendy should allegedly be charged allegedly. Okay? But that is it for this video. Before I let you guys go, I enjoy making these videos for you guys, and I hope you guys enjoy them. If you guys have any disagreement with me, go ahead and just tell me down below. If you agree with me, let me know that too. If you like this video, can you let me know what you like about it? If you don't like this video, go ahead and tell me what you don't like about it. But please make sure you like, comment, share, and subscribe. Until next time, y'all take care.